Yes, Mr. Wordsworth.
My lord,
All the seats are taken. There are more seats at the back if anybody would like to sit down. Yes.
my lords, my lady, thank you. I act with Mr. Webster and also Mr. Hotfield, who unfortunately is unwell, so is attending online, for the Appellant Republic of Korea, and my learned friends Mr. Partasides, Mr. Petropoulos, Mr. Stafford and Mr. Clark act for Elliott Associates. You should have received 2 skeletons from each party, one going to the main core of the appeal, the other a supplementary skeleton going to the issues on the US diplomatic note and related note from the Republic of Korea. If I can plunge straight in, for your reference, the dispute in the arbitration and the award are as described in Mr. Justice Foxton's judgment at paragraphs 3 to 16, and that's at Core 6. But I'd like you to take you right away to the key issue on appeal, which turns on Article 11.1.1 of the Chorus FTA, and that's at Core 9, page 264. Yes. If you see that, Chapter 11, Investment, Section A, Investment, Article 11.1, Scope and Coverage, this chapter applies to measures adopted or maintained by a party relating to A, investors of the other party, B, covered investments, and C, with respect to Articles 11.18 and 11.10, all investments in the territory of the other party. We're not really concerned with 11.1c at all. Those are specific provisions dealing with performance requirements and don't enter into the case.
Could I just interrupt you for a moment? We have Opus documents on screen.
My lord, I hope so, yes.
But are we going to have access to the Opus workspace?
That, I'm afraid, I do not know the answer.
Because there's not much use in following the Opus on screen rather than hard copy if I can't mark it.
I would have. All the Opus people seem to have disappeared, my lord, and okay. Okay. Apparently, you do not. I apologise.
Well, I know I don't have. I know I don't have access to it.
To the
workspace.
So it's there for your convenience to go to the PDFs. Obviously, it's the same as in the bundles.
But there must be an operator. Who's operating it? Yes.
I can ask the case manager. I'll get them to if you want the access.
I'm just surprised. I've used Opus a lot.
Yes,
but I've never been presented with it on screen, but not being able to access it. It just seems a bit rather a waste of money.
My lord, I absolutely see the problem with that, and I myself, I can't say why there is no proper access to it. But I do apologise for the inconvenience, which can be considerable.
It's not inconvenient, it's just not as convenient as it might have been.
No, I do see that, my lord.
Yes, thank you.
It may be more easy than, at least for present purposes, to be working from the hard copy of the core bundle particularly, and obviously I'll be spending a lot of time in the core bundle particularly at the moment, core 9, page 264, where you can see on article 11.1.1 Korea's case is that this article conditions the application of Chapter 11 as a whole, such that Chapter 11 does not apply, both as to its substantive and its procedural protections, unless the Article 11.1.1 requirements are met. Now the question on appeal is whether that is correct, or whether, as the judge found, the words "this chapter" are correctly understood as just a reference to section A of this chapter and not to section B, which includes the arbitration provisions, such that the existence of the consent to arbitrate is not dependent on an investor satisfying the requirements of Article 11.1.1. My Lord, I see perhaps you're looking for where section B starts. Section B starts at page 272 of the core bundle. Can you see that?
Oh, I see.
At the bottom.
At the very bottom of the page.
And there you see, just for a little bit of early guidance, if I may, 11.15 deals with consultation and negotiation. 11.16 deals with submission of a claim to arbitration. And then 11.17, which is at page 275, is in many respects a critical provision, because this of course provides for the consent to arbitrate. As it says in terms, consent of each party to arbitration, each party consents to the submission of a claim to arbitration under this section. So you see there, where they mean the word section, they say the word section, and then in accordance with this agreement. And again, we say, where they mean agreement, i.e. something broader than this section, they've used the word this agreement. So our case is genuinely a very simple and straightforward case. I'm sure you, my lords, my lady, you've heard that before, but it really is the case on this appeal. Because looking back at 11.1.1, it provides this chapter applies to certain measures relating to investors, covered investments, and the like. The words this chapter are completely unambiguous. The treaty parties could very easily have said this section. You've just seen the word this section in 11.17, where they were clearly talking about the submission of a claim under section B. But here they used the words this chapter. They did not use, as the judge in effect said, the obligations under section A of this chapter apply to measures adopted or maintained by a party, etc. That was his interpretation. And we say that's wrong, and applying the usual rules on treaty interpretation, this chapter means what it says, and it naturally includes the entirety of the chapter. And it follows that unless these set criteria of 11.1.1 are met, then the chapter simply doesn't apply. And that includes the entirety of the chapter, both section A and section B. And there is no consent to arbitrate, because consent to arbitrate, that's contained within section B. You never get to section B, because you start your natural reading of this chapter with the very first provision. So this provision conditions the consent to arbitrate. Now that's also confirmed, I'll come back to this in a little detail, but that's also confirmed by the way you see the words this chapter being used in all the provisions around 11.1.1. For example, just take as an example, 11.2.1, in the event of any inconsistency between this chapter and another chapter, the other chapter shall prevail to the extent of the inconsistency. Of course, that means the entirety of the chapter. Now, it's also confirmed by the diplomatic notes exchange that I'll take you to shortly, but it's also confirmed by a very, very long history of both state practice and tribunal awards with respect to the almost identical and materially identical provision in 11011 of the North American Free Trade Agreement, the NAFTA. And with your leave, I'll take you to some NAFTA cases later to make that point. Now, you've also seen the second sort of main crux of our argument, which is that if it were necessary, as the judge to a very significant extent seemed to think, that you have to find some express limitation within the confines of Section B, well then I've just showed you that in 11.17. The critical provision, that's back at 275, if I can take you back to that, that is consent to arbitration. Each party consents to the submission of a claim to arbitration under this section in accordance with this agreement. It's not in accordance with this section, and that is exactly how the judge interpreted that word, this agreement. He interpreted it as being a reference to the procedural conditions within Article 11.16. Well, with respect, that made no sense, because if that's what the parties had meant, there are 2 points really. One, they would have said under this section, in accordance with this section, but the real answer is they wouldn't have used the words in accordance with this agreement at all. They would have just said, each party consents to the submission of a claim to arbitration under this section, full stop. But they didn't do that. They said in accordance with this agreement, and that brings in many other provisions that go to the existence of the consent to arbitration. That includes Article 11.1.1, which I've already shown you, but it also includes various other provisions, important provisions that go to the existence or not of consent to arbitrate. Now, I'll take you back to all that in a moment. My lords, my lady, if I can make my submissions in the following order. First of all, I'd like to make some introductory comments focusing really on the correct approach to interpretation as a matter of international law. I think the court will already be familiar with the Vienna Convention on the Law of Treaties, Articles 31 and 32, but I would like to take you to some of the authority on that, which assist, we submit, in making Korea's points good. Then, of course, it's necessary to look at the key provisions in Chapter 11 in some detail, of course 11.1.1, but also the provisions that the judge focused on more. Third, I propose to look at the diplomatic notes, the exchange of notes between the USA and Korea, those of course being the masters of this treaty and having a very special role to play within the Vienna Convention on the Law of Treaties as to this agreement of what these words actually mean. And there are issues there as to the admissibility of those notes and also to the weight of those notes. And I'll need to look at those in a little detail. And finally, I'll be looking at some of the English cases on Section 67 that the judge put some weight on at paragraph 37 of his judgment, where he sought to draw some principles out of really just a very few English cases that have had to look at the wording of an investment treaty. Not this investment treaty, but different investment treaties. We say actually, insofar as he's trying to establish principles as a matter of English law, those are not relevant. Indeed, there's no space for such principles, because the parties agree that if, as a matter of international law, Article 11.1.1 conditions the existence of the consent to arbitrate, then of course that is a matter that goes to substantive jurisdiction within Section 67 of the Arbitration Act. So English law, domestic law principles really don't play a role there, although it seemed that the judge was trying to use those principles as some sort of a filter. So, my lord, if I can start then with the Vienna Convention on the Law of Treaties,
Could I just get our bearings? The reason why the Section 67 application, the arbitration claim, was brought in the commercial court, that's because the arbitration was established in London. Is that right?
My lord, that's entirely correct.
So it's a English-seated arbitration.
My lord, yes.
Thank you.
But the point I'm making is, yes, of course, there's no issue as to the English courts being the law of the seat and being the correct court to hear challenges, but in identifying the key issue which goes to substantive jurisdiction, was there consent to arbitrate or not? Well, you're applying a treaty, and that treaty you have to interpret by reference to international law. There can be no question as to that. That's why we say the judge's principles are in fact unhelpful, but also misconceived.
Well, is it more that they're by the by because you say it's common ground, that
Well,
if 11.1 conditions 11.16, that's the only, then it would be a matter
My lord,
of substantive jurisdiction.
absolutely.
So,
So,
in other words, there's no dispute, you say, on that premise as to whether Section 30 and 67 apply.
yeah, on that basic premise, there is no dispute. Nonetheless, the Elliott does rely on those principles of the judge, because they are saying, well, they help shape the debate and help you understand what is truly jurisdictional and what, on a closer analysis, goes to admissibility or to the merits. So I do have to engage with the principles to an extent, at least to show you the principles and to show why, in actual fact, they do not apply. But in any event, the basic position is there is no role for such English law principles here. We're looking at the treaty, and I absolutely understand it to be common ground. If, as a matter of international law, there is no consent to arbitrate because of Article 11.1.1 and 11.17 correctly interpreted as a matter of international law, then it follows that the substantive jurisdiction test is met. My lords, my lady, can I take you to a recent and unanimous Supreme Court decision, JTI Polska, which is in Authority Bundle 2, tab 60, 4535. And you see, in fact, that this was a 7-person court. It was dealing, in fact, with the interpretation of a treaty called the CMR, which deals with contracts for international carriage of goods by road. And if I can ask you then to turn to where conveniently they set out and they consider Articles 31 and 32 of the Vienna Convention on the Law of Treaties, and that's at page 4546. Yes, volume 2 of the authorities bundle.
My volume 2 of the authorities bundle starts at tab 62. It seems to be a repeat of bundle 3 mislabeled.
That is a
There's volume 2.
very
It starts
regrettable.
at 62.
I think Mr. Webster is saying that his version is not marked up so that he may be able to hand up to you JTI Polska in clean form.
Well, is this going to be a recurrent problem? My volume 2 has tabs 31 to 61, so
Yes.
JTI Polska is almost at the end. If my lord has been given 2 copies of volume 3 and none of volume 2, we'd better tackle that now.
My lord, yes. Is that what's happened, has it?
Yes, I have bundle 2. Bundle 2 starts at tab 62 and goes to tab 82.
Right.
And bundle 3 also goes from tab
Yes.
62. It's quite simple. It's quite a simple. Some
Yes.
of the,
Okay. I do apologise.
Somebody has an unmarked bundle which
Yes.
they could sacrifice. We'd be able to get on.
yes, thank you.
My lord, I do apologise.
Right, JTI Polska, tab 60.
Yes, and if I could ask you to turn to page 4546, where you can see the court is starting the exercise of interpretation, and it sets out Articles 31 and 32 of the Vienna Convention on the Law of Treaties. You see Rule 31.1, a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. And then there's some helpful discussion on what is meant by that provision at paragraph 26 towards the bottom of the page. Article 31 focuses on seeking to ascertain the ordinary meaning of the relevant terms of the treaty, having regard to their context and the object and purpose of the treaty. This is done by reference to the text of the treaty and to the material set out in Article 31.2 to 31.4, such as its preamble, as a single combined operation. I'm making that point there because it's not as if 31.1 is obviously a basic rule, but you're looking at the entirety of 31.31 as a single combined operation. So Lord Kerr of Tonamore explained in the Muhan case it would be wrong to read Article 31 as reflecting something like the so-called golden rule of statutory interpretation, where one starts with the ordinary meaning of the words and then moves to other considerations only if the ordinary meaning would give rise to absurdity. That is not international law. The International Law Commission made clear in its commentary to the draft treaty at page 219 that in accordance with the established international law, which these provisions of the Vienna Convention codified, such a sequential mode of interpretation was not contemplated. The Commission, by heading the article General Rule of Interpretation in the singular, and by underlining the connection between paras 1 and 2, and again between para 3 and the two previous paragraphs, intended to indicate that the application of the means of interpretation in the article would be a single combined operation. So looking then at the other provisions of Article 31, 31.2 just tells you more on what the context is for the purposes of the interpretation of a treaty. For example, in addition to the text, it includes its preamble and annexes. Then Article 31.3 is of very real importance in this case. There shall be taken into account, and of course that's mandatory wording there shall be taken into account, together with the context, any subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions. Again, 31.3b, perhaps slightly less important because we have an actual agreement in this case on the meaning, the intended meaning of 11.1.1. Any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation. And then the remaining provisions of Article 31 are not of any particular importance in this case. Now, my lords, my lady, I dwell on Article 31.3a because of the diplomatic note in this case. And if I could take you to that for an early sight of it, obviously I'm going to come back to the issues of admissibility and weight. I think it's useful to the court to see up front what it says. And this is an application bundle tab 4.1. So at page 42 of the application bundle, and you see the Embassy of the USA in the Republic of Korea presents its compliments to the Ministry of Foreign Affairs of the Republic of Korea. In reference to the judgment of the High Court of Justice of England and Wales, King Bench Division, in the matter of Republic of Korea versus Elliott Associates L.P., the United States writes to confirm its understanding regarding the interpretation of Article 11.1 scope and coverage of the Korea-US Free Trade Agreement, the Chorus FTA. Note there its rights to confirm its understanding. Article 11.11 of the Chorus FTA provides that this chapter, that is chapter 11 of the Chorus FTA, applies to measures adopted or maintained by a party relating to A, investors of the other party, B, covered investments, and C, with respect to Articles 11.8 and 11.10, all investments in the territory of the party. Article 11.11 defines the scope of Chapter 11 in its entirety, including both the substantive investment obligations in Section A and the investor-state dispute settlement mechanism detailed in Section B. To conclude that Article 11.11 applies only to Section A of Chapter 11 and not to Section B is incompatible with the provision's ordinary meaning, specifically its opening reference to this chapter and not this section, and would therefore be inconsistent with the customary international law principles of treaty interpretation as reflected in Article 31.1 of the Vienna Convention on the Law of Treaties. Because Article 11.11 applies to the dispute resolution provisions in Section B of Chapter 11, a tribunal constituted under Chapter 11 has no jurisdiction unless Article 11.11's requirements are satisfied. This is confirmed by in Article 11.17, which provides the chorus FTA parties consent to arbitration. Article 11.17 is expressly limited to claims submitted in accordance with this agreement, i.e. the chorus FTA. Claims that are
Mr Wordsworth, I'm sure you don't need to read it out as slowly as that, especially as it reproduces verbatim what you were submitting minutes ago. We can read it.
If I could ask you to read the remainder. I was reading it out actually because there's an issue as to transparency, and I just wanted to be reading it out in open court.
The established position there, isn't it, is that the way that this is analysed is that a treaty between two states contains an offer to arbitrate to investors.
My lord, yes.
When exactly they accept or in what way may be a matter of dispute. That's the nature of the beast.
My lord, yes, entirely correct.
So there's something slightly discomforting about the proposition that an offer to arbitrate contained in the treaty, as has been accepted, has led to an arbitration, but now the states are agreeing between themselves after the event what that offer to arbitrate means. And that seems, on the face of it, to be moving the goalposts after the offer has been accepted.
My lord, I fully understand that argument, but this is not a moving the goalposts case, because as the US is saying here, making very clear, this is consistent with its long-term, consistent interpretation of Article 11.
If that's the case, that will be seen from the materials that demonstrate it.
My lord, it is seen from the materials that demonstrate.
I'm not sure that a subsequent affirmation of that really takes us anywhere, and as I say, gives rise to a degree of discomfort as to what's being done.
My lord, I see the point, but that does tell one that this is not a shifting the goalposts point. This isn't as if you have an interpretation of a treaty that comes out of the blue after the commencement of a dispute. All that has happened is, in this case, after the judgment of Mr Justice Foxton, the two parties have exchanged diplomatic notes that confirm their existing interpretation. And that is an existing interpretation by reference to, on the US's part, 20 years under the NAFTA, and also one submission in the chorus FTA. Insofar as concerns Korea, it's consistent position across 3 cases.
But surely we must interpret this treaty as at Well, primarily as the date it was entered, but particularly insofar as there are any subsequent expressions by the states of their views, as at the date the arbitration offer was accepted.
I would absolutely, yeah.
And so, but to interpret it on the basis, even allowing for the relevant provision of the Vienna Convention, to interpret it now based upon matters which post-date the acceptance of the offer to arbitrate seems to me to be dubious in the extreme.
My lord, there are two answers to that. One is that the Vienna Convention mandates you to take this into account. Okay, shall take into account a subsequent agreement.
But subsequent to when? Can you take into account something which is... And I understand that when you come to interpret, as Mr Justice Foxton did, he looks at the treaty and any agreement between the states as to what it means. Was it really the case that the states that we can then take into account a yet subsequent expression which is written after that judgment, when we are considering whether Mr Justice Foxton was right when he interpreted it when he did?
My lord, yes. And there's a, when you look at that way the Singapore Court of Appeal approached this in the Salem case, it played considerable weight to the specific issue that you've highlighted, and it introduced the concept of the critical date. So in that case, it did admit into evidence note verbals after the dispute was crystallised, and indeed after the first instance decision. But its concern in terms of whether this was shifting the goalposts, it addressed by saying, well, is this interpretation confirmatory of an existing position, in which case it can be accorded weight? Is it confirmatory of a reasonable interpretation as opposed to the reasonable interpretation, which we say is the case here? Then again it can be accorded weight. But whereas in that case, in effect, what the two states concerned were doing was to contradict the existing position, then they accorded it no weight at all. So they took account precisely of the discomfiture that your lordship has given voice to, but by reference to a critical date concept. They, and my lord, it may be helpful to take Salem out of order, or I'll come back to that issue to make the point good a little later.
Well, you take your own courses.
Thank you very much, my lord. I had planned to come back to the issue of the notes and the weight to put onto them a little later, so I will continue with that course.
Yeah.
My lord, just on staying with the Vienna Convention on Article 32, again one can see that from the JTI Polska case at 4546, where it says recourse may be had to supplementary means of interpretation, including the preparatory work of the treaty and the circumstances of its conclusion, in order to confirm the meaning resulting from the application of Article 31, or to determine the meaning when the interpretation according to Article 31 leaves the meaning ambiguous or obscure, or leads to a result which is manifestly absurd or unreasonable. And then you see at paragraph 28, Article 32 then allows for recourse to be had to supplementary material, including the preparatory work of the treaty and the circumstances of its conclusion in order to confirm the meaning, which results from the application of Article 31 in order to determine the meaning. Such material may only be used to determine the meaning when the interpretation, according to Article 31, leaves the meaning ambiguous or obscure, or leads to a result which is manifestly absurd or reasonable. The reason I take you to that is that in due course I do want to take you to some article, what we say are Article 32 materials that confirm the meaning that one arrives at through Article 31 of the Vienna Convention. And those Article 32 materials, my lord, address in part the point that you are making, because they go to the fact that the parties, or certainly the USA, already had a settled interpretation of the equivalent provision in the NAFTA, Article 1101(1), before the FTA. So before the FTA came into force. And you can also look at subsequent practice under Article 32. So also within Article 32, you are permitted to look at what happened next. My lord?
Sorry, can you clarify, you're not, are you saying that this is a case where we should be confirming the meaning by supplementary means of interpretation?
Yes, yes, my lady.
Rather than determining it?
My lord, my lady, yes. Because we say, absolutely, there's no ambiguity here. It's all absolutely clear. But that is confirmed by reference to supplementary means. And
32 on its face doesn't allow you to look at subsequent material, does it? Well, not obviously so, but that's your position. There's a reference to subsequent material in 31(3).
Yes, my lady, absolutely correct. I'm going to take you to some relevant international law materials which explain how within Article 32 you can look at subsequent practice, including subsequent practice of just one state. So it's as if it's a sort of a lower version of 31(3). So instead of subsequent agreement, which shows subsequent practice, which shows the agreement of the parties on interpretation, it's just subsequent practice more generally, which may be of just one party, in fact. So, my lords, my lady, if I can then take you to the FTA itself in a little bit more detail, and you can see this starts at 49117. And an obvious point, but of course this is a free trade agreement between the Republic of Korea and the USA, and it's entirely up to these two treaty parties to establish whatever investment protections they like, whatever consent to arbitration with respect to the application of those protections they see fit. That's entirely a matter for them. There is no position under international law where there is a default existence of jurisdiction. It's very, very common indeed, as a matter of international law, for there to be some substantive protections, but for there to be no consent to compulsory dispute settlement with respect to those protections. And you can think, for example, of the most foundational international law agreements, like the UN Charter, like the 1949 Geneva Conventions. There's no compulsory dispute settlement mechanism in those, so there can be no presumption at all that in any given treaty the states concerned have consented to jurisdiction in some way. Then moving on to page 120 of the core bundle, you see chapter 1, initial provisions and definitions. I needn't linger on that, although I do note that on page 122 there's a definition of the term measure, which then filters into Article 11.1.1. Measure includes any law, regulation, procedure, requirement or practice.
Is there any significance in the word includes as opposed to means?
Potentially there is. That's not a matter before you, my lords, my lady. There is a matter on the jurisdictional challenge, if the merits of that challenge are subsequently held, as to precisely what measure means. And does it mean literally any act or omission, which is the Elliott position, or does it mean a measure of some sort of formality, governmental formality, which is Korea's position? But it's not an issue before you today.
Isn't it?
No, because that would be application of the criteria of Article 11.1.1, i.e. was there, if it is accepted, as Korea says, that Article 11.1.1 goes to the existence of the consent to arbitrate, well, then you have to see if the requirements are met. So then you'd have to see, well, is there a measure of a party? But that's not an issue for you today. The only issue for you today is, does, as we say, Article 11.1.1 condition the application of the entirety of the chapter, and hence the existence of consent to arbitrate in section B, or does it just condition the application of section A of the chapter? That's the only issue before you today. And that's why I say our case really is a genuinely simple and straightforward case, because our case is simply Article 11.1.1 means what it says. And if I can perhaps try and make that point further by looking again at Article 11.1.1 and the provisions around it.
Whilst you're in the definitions, there's no definition of investor dispute.
My lord, that's correct, there isn't. And so the judge effectively defined that as a dispute concerning investments.
Is there a definition of investor, anyway?
There is a definition of investor. That's see, these, my lord, because this is a free trade agreement, you have some definitions right at the beginning in chapter 1, but then you have specific definitions at the end of chapter 11, where some of the defined terms are contained that are relevant to chapter 11.
Yes, although investment isn't defined in section 1, covered investment is.
My lady, thank you very much for reminding me.
Which is, that seems to be the other relevant definition.
Exactly. I wish to, I'm grateful for that, because that also feeds into Article 11.1.1. So if I can ask you then to move on to Chapter 11, Investment, at 264 of the core. Now, of key importance, we would say, this is the very first provision that you come to in Chapter 11. And that helps you identify, by reference to context, that it is intended to condition all that follows. You also get that from the heading, scope and coverage.
But the judge looked at a number of the other chapters and the scope and coverage provisions in those as well, didn't he?
Yes, he did. He did, my lord. And I was planning to come back to the points he makes there. But actually, my lord, can I say this up front? That his analysis there actually is inconsistent with the reasoning in his judgment. Because what he is saying is, with respect to those other chapters, the scope and coverage provision is essentially descriptive. It just tells you what that chapter is about. But that is not how he approached the meaning of Article 11.1.1. His view was that this was not descriptive because, as you will have seen from the judgment, he interpreted this chapter as meaning the obligations under Section A of this chapter apply to measures adopted or maintained by a party relating to A, B and C. So he accepted that this was a precondition. On his argument, on his reasoning, this was not merely descriptive.
Well, it clearly, as I understand it, insofar as it restricts the application to measures, that must be a substantive restriction.
Yes, my lady.
Whether it applies to the section or to the chapter is another matter.
Exactly, my lady. So that's the point I was trying to make, because essentially the judge was looking at the certain other chapters and saying, look at chapter 8, for example. And perhaps it'd be useful to do that now while we're on the point. So he says, well, look at chapter 8. And that's at page 236 of the core bundle. There you have Article 8.1, scope. This chapter applies to all sanitary and phytosanitary measures of a party that may directly or indirectly affect trade between the parties. He then says, look at 8.3 on establishing a committee on sanitary and phytosanitary matters. From that, he deduces that Article 8.1 is really about describing what the chapter is about, and then his reasoning is, well, you don't have to show you're within the scope of this chapter in order for the parties' agreement on establishing a committee to come into effect. Now that might tell you something about chapter 8. We are not concerned with chapter 8. We are concerned with chapter 11. It cannot be said that chapter 11 is article 11.1.1 is merely descriptive. It, as my lady said, it conditions what the application of what follows. The only question is, does it condition the application of just Section A obligations, or does it condition the entirety of this chapter, as one would get from the words, this chapter? So the points on what the other chapters are doing, it doesn't help in the reasoning. Some might be just descriptive. Article 11.1.1 plainly is not. And the judge did not interpret it as being descriptive. So my lords, my ladies, the judge did place some weight on the fact that Article 11.1 is under the heading Section A, investment. But we say that tells one nothing at all, because that's just duplicating what Chapter 11 heading is. So Chapter 11 and investment, Section A, investment. And then one gets to the critical wording. This chapter applies to measures adopted or maintained by a party relating to A, B or C. So you already have my basic point. Applying usual rules on treaty interpretation, this chapter means this chapter, naturally means this chapter as a whole. And in fact, there can be no debate as to the ordinary meaning of the words this chapter. But of course, if the parties had meant to mean this section, they would have said so. And one can see that from other provisions on the scope of application in the treaty. So if, for example, I could take you to page 476 of the core bundle, and here we are sort of towards the end of the FTA, dealing with matters such as establishing a joint committee, and here you have section B on dispute settlement proceedings. And then looking at 22.4, scope of application, except as otherwise provided in this agreement or as the parties otherwise agree, this section shall apply with respect to the avoidance or settlement of all disputes between the parties regarding the interpretation or application of the agreement. So plainly, they know how to use the word this section, if that's what they mean, in a scope of application provision. So those are all points based on the ordinary meaning of the terms this chapter. If I can take you back to 264, 11.1.1, and then to look at the context, because of course you're looking at the ordinary meaning of the words in context. And looking at the immediately following provision, 11.1.2, the greater certainty this chapter does not bind either party in relation to any act or fact that took place or any situation that ceased to exist before the date of entry into force of this agreement. Again, that naturally means this chapter, the chapter as a whole, including the dispute settlement provisions, because one would not expect the dispute settlement provisions to be establishing jurisdiction with respect to events that came to an end before the treaty came into force.
Forgive me, so just to get this in context, this is looking at disputes between the contracting parties.
My lord, yes, sorry, Article 22.2 is
Yes.
correct, yes.
So forgive me, what is the relevance of that to the dispute resolution in Chapter 11?
Because I was just seeking to show you, my lord, that where you have a scope of application provision, and they are trying to restrict that to this section as opposed to this chapter, They just use that word. That's the only point. Perhaps it's a laborious one. But it's one that follows very naturally from the careful attention that these two states have obviously paid to how their treaty works. And they use this chapter, 11.1.1, because they mean this chapter. Same for the other sub-provisions, 11.1.2 and 3.
Well, just get into the nub of the words in Article 11.1. And you say that the words are clear and on their face, but what does it actually mean? This chapter applies to measures, and how does that relate to a subsequent agreement to arbitrate? The language doesn't naturally sit comfortably, does it?
Well, my lord, yes, because it is saying what is the scope and coverage of this chapter. And naturally, interpreting the ordinary meaning of the words is saying what the chapter applies to.
Yes, but you've got to interpret the words as you say in their context.
Absolutely.
The context includes the words to which my lord has just referred.
Applies?
Yes, it's not the most natural meaning.
Well, I think that the point my lord is making is that you don't have the word only before applies. But
no, I think the point I'm making is that if you wish to say that it is a condition of the provisions in this chapter applying that it is in the context of measures, you could say so. But what it says is this chapter applies to measures, and then you say if there is a dispute concerning an investment dispute, it's not clear how you say, well, that doesn't apply to measures. It doesn't fit very neatly at all. You've got to read some words in, haven't you, to make it work?
no, I would suggest not, my lord, because the chapter only applies to certain stated objects. That identifies the scope and coverage of, we say, the entirety of the chapter. The judge said just the obligations under section A. But that's my point, that it's not descriptive at all. It is saying, in a way that's entirely standard wording in treaties, what the gateway is into the application of the treaty. And you don't get into the application of the treaty. The treaty simply does not apply unless you tick certain boxes. So the treaty does not apply, for example, if you're not an investor of the other party. Save for if you are a covered investment. These are absolutely critical protections for investors and investments, and the treaty parties are doing something very common, which is to establish the precise scope of application of their treaty. Otherwise, the person is outside the scope of protection of that treaty. So we say we're giving entirely the ordinary meaning to the words, and also, of course, I'm going to come back to how this language has consistently been interpreted, but it has consistently been interpreted under the NAFTA as a gateway to the application of the entirety of the chapter.
one thing I think you will also need to address, Mr Wordsworth, I'm sure you will, is 11.16 appears, at least to me at the moment, to be capable of working by itself in a sensible fashion, and in particular has its own provisions which confine its application, for example, to investors.
Certainly.
And include effectively the sort of timing limitation that's in 11.1.2. And I think that the judge didn't put it quite like that, but I think that was one of the points he was also considering.
And later, yes. But there are two answers to that. And obviously I'm going to come back to the detail.
Yeah.
But if it is correct, as many tribunals and the state's parties to NAFTA, the equivalent provision, have said that this is a gateway to the application of the chapter including 11.16, simply does not apply. You never get to 11.16. That makes absolute sense, even when you're just focusing on 11.16, because you're interpreting 11.16 in its context. So is this a freestanding consent to arbitrate, or looking at it by reference to 11.1.1, is there already some sort of prior condition that has to be satisfied before you get to 11.16?
For me, maybe another way of putting it is, I'm asking myself, rightly or wrongly, the question of why 11.16 is drafted in the way it is, if 11.1 governs it.
Well, it's consistent with 11.1.1. I think that may be a point my ladyship is making, because you see some of precisely the same sort of jurisdictional preconditions there, so far as concerns the existence. There has to be an investor, there has to be an investment, although you don't get that in any way as clearly as you get it from Article 11.1.1, which is why we say that's more clearly concerned with establishing jurisdiction. But also the consent to arbitration, again, as I made the earlier submission, it's consent to arbitration under this section in accordance with this agreement. And that brings in the entirety of the agreement. It has to bring in the entirety of the agreement. And I'll show you in due course why the judge's interpretation of 11.17 as just referring to in accordance with this section is not correct.
Well, can I ask whether I understand the critical point correctly? If we look at 11.16, it uses the phrase an investment dispute, which you've told us is not defined. On the face of it, that's very broad. But you say it must be read subject to 11.1 so that it means a dispute about a measure. And if it's not a dispute about a measure, then there's no consent to arbitration at all.
That is correct.
Yes. And any dispute which doesn't concern a measure, the dissatisfied party has to find a court somewhere which will say that it has jurisdiction. Is that right?
My lord, yes, but a measure, I've already shown you the definition. That's essentially any form of governmental act. Obviously, there's a dispute as to whether there has to be any formality to that. But why would the parties be agreeing to consent to arbitrate something which was not a form of governmental act? They are, of course, they're limiting the scope of their consent to arbitrate to their own acts. So the absence of the word measure in 11.16, although it does appear elsewhere, it's not in 11.16.1, is of no consequence. The point I think that's troubling your Lord is you think, well, hang on a sec, there should be a sort of a broad available remedy. But one, why should the treaty parties be agreeing to arbitrate with respect to matters that are not governmental acts? That's difficult to follow. But in any event, consent to jurisdiction in international law, that is the exception. It's not something that states find themselves agreeing to easily. They are very careful indeed, and they prescribe always limits on their consent to arbitrate. It's very, very common indeed.
Anyway, the point is, you say that in 11.16 has to be read subject to the fact that unless the dispute is about a measure, the agreement doesn't apply at all.
My lord, correct.
Ah, that's your case.
Yes, absolutely.
What about 11.16.1c A1c, breach of an investment agreement? Does that have to be a measure?
You have to, absolutely, you have to satisfy the chapter 11.1.1 requirements to get within this treaty or this chapter. So ultimately, you are going to have to establish that you have a qualifying measure in order to get into section B. Again, that shouldn't be a matter of consternation. Think about the fact of the investment agreement. In the usual course, and this is defined, it's got to be between one of the treaty parties and the investor. In the usual course, that will almost certainly have its own dispute settlement mechanism. But what you're doing here is within this treaty, you are creating exceptionally a specific treaty remedy for the parties to that investment agreement. So no surprise at all that in order to have access to that exceptional treaty remedy, you have to satisfy the treaty criteria, the application for criteria of the treaty.
So any other breach or alleged breach of an investment agreement that didn't involve a measure would have to be settled under whatever dispute mechanism, if any, the investment agreement provided for.
Well, absolutely correct. And that's a point that the judge identified.
Yeah,
Correctly,
indeed.
he paid little weight to it because it is very common indeed in international law to have a situation where you have split fora. It is very common. You have let's say a consent to arbitrate where the parties only agree to arbitrate disputes with respect to the compensation due following an expropriation. So if, for example, you have a dispute as to breach of the fair and equitable treatment standard, or national treatment, or something else, then you're going to have to find some other forum. That is standard in the world of investment treaties, that you may not have an all-inclusive coverage so far as concerns the consent to arbitrate. And my lady, you actually get that sort of potential for split fora even within 11.16. Because although the judge said, well, the agreement is to arbitrate all investment agreements, well, that's not correct, because the proviso...
Dispute.
Sorry?
The agreement arbitrate all investment.
No, sorry, I'm sticking, my lord, for the moment with disputes concerning investment agreements. Sorry, I put it clumsily, I apologise. But you see, it's not an agreement to arbitrate all disputes concerning investment agreements because of the proviso, provided that the claimant may submit pursuant to subparagraph A1C or B1C a claim for breach of an investment agreement only if the subject matter of the claim and the claim damages directly relate to the covered investment that was established or acquired, etc., in reliance on the relevant investment agreement. If you can't meet those criteria, then inevitably you're going off to another forum. So, I see my lady's point very, very forcefully.
Well, just to go back and make sure I've understood, you referred to expropriation, you meant that as an example of a measure, of something that would be a measure.
That would certainly be a measure, yes.
Whereas other breaches of investment agreements would not.
No. Sorry, my lady, I was not sufficiently clear. I was just taking that as an example. So forget about scope of application provisions just for a moment. In a consent to arbitrate provision, it is very common for the consent to arbitrate not to be with respect to all the substantive protections in the treaty, but simply to be with respect to one very limited subject matter. Because states are some states are very reluctant to agree to arbitrate. And they will only agree to arbitrate something very particular. The example I happened to give was one concerning...
I understand, yes.
Sorry, I didn't make that clear.
Yeah.
And going back to Article 11.1.1, scope and coverage, we do say, and I think the judge agreed with us to this extent, that on its natural meaning applies to measures adopted or maintained by a party relating to investments and covered investments. That did have a conditional impact. And his only query as to what it was conditioning. So he understood that wording as naturally conditioning application of something on the need to meet those criteria. But he said Section A, not this chapter. We say this chapter means this chapter, because you can see that from the ordinary meaning of the words, you can see it in context. When, for example, if you go to Article 11.2, in the event of any inconsistency between this chapter and another chapter, the other chapter shall prevail to the extent of the inconsistency. Again, that must mean this chapter as a whole. And yet, if I can take you to the judgment at Core 6, page 85, he said, paragraph 40, section A is principally concerned with the substantive protections afforded by the treaty. Then at 2, well, he makes his sort of big point at 11.40.1. Section A includes Article 11.11, which I've quoted at 7 above, and which identifies what this chapter applies to. While Korea can argue that the offer to arbitrate in 11.16 forms part of Chapter 11, the argument that Article 11.11 places limits on the scope of the offer to arbitrate is inherently less compelling than the position where reliance is placed on the express terms of the offer to arbitrate for the purposes of establishing a jurisdictional limitation. Article 11.2 addresses the relationship between Chapter 11 and other chapters, and the application or non-application of Chapter 11 to particular types of measure. Once again, they are concerned with the substantive provisions of Chapter 11. And then he says the remainder of Section A sets out the substantive provisions afforded by the treaty in this respect. And you can see that from his then, the interpretation that he's then making over 41, he is still understanding this as limiting the scope of application. But he's saying, he refers to the argument we were making at 41. However, given its appearance in a section which is otherwise concerned with substantive provisions, I accept Mr Partasides' Casey's submission that Article 11.11 can be read as defining the scope of the substantive provisions of Chapter 11. So interpreted, the concepts of scope and coverage still make sense, defining the types of investor, investment and state action against which substantive protection is given. So he does understand this, and we say absolutely correctly, to be defining the scope of application, but he just says it's the scope of application of Section A, not Section B, which we say is not giving effect to the words this chapter.
But in a broad sense, if you say this chapter applies to measures, then an arbitration provision can apply to the question about whether they're measures. The wording still works, doesn't it?
No, my lord, because it's not there as something which serves no function really other than as being descriptive.
But surely it does. Surely it does, because it helps you to. It means that you understand that when you are looking at investment disputes, they must be about a measure.
No, because it's really, as we understand it, a sort of a cart and horse point. Because you are not getting to Section B, the offer to arbitrate, until you have satisfied the provision which deals with the scope of application of the entirety of
But
the
what
chapter.
happens if there is a dispute as to whether or not it is a measure?
Then you have the tribunal, of course, can decide that as a matter of its competence.
Yes.
So it decides that.
Yes.
That's
And then you
absolutely
challenge it
fine.
under section 67.
Absolutely.
I understand that's what you say, but why is it inconsistent to say that, as I say, the only wording is this chapter applies to measures. It doesn't say, it doesn't say in terms or otherwise that it it is a condition of any part of this chapter applying that there is a measure.
Well, we would submit that is the natural and established meaning of these words. This chapter.
Well, I really do
applies.
understand that's what you say.
Yes, but can I take you to some cases then, my lord? Because clearly you're not thus far convinced on the point.
Well, I'm just testing your argument.
All right,
yes,
before you go anywhere else, let's take a short break, 5 minutes or so, and then we'll resume. Justice to work.
My Lords, my Lady, so I'm being questioned on 1116 and how it interplays with 11.1.1.
Yes.
Can I just make a point before I take you to some of the cases on the 11.1.1 wording, which is you look at 1116, and in order to establish its jurisdiction, i.e. this is competence, the tribunal has to decide, for example, whether there is an investment or not, okay? That can be a very fact-intensive issue, but for the purposes of jurisdiction and substantive jurisdiction as a matter of section 30, section 67, that is a jurisdictional fact, okay? And it's the same, the judge emphasised that looking at the definition of claimant, then you get to the necessity for there to be an investor. Again, in order to decide whether there is an investor or not, that can be a heavy factual question as to whether the investor was incorporated in the state, whatever the criterion may be, or whether it's a dual national, and you are allowed to be a dual national under this treaty, then that leads you to an effective nationality test. So again, that's a very fact-complex question. Of course, you've got to establish the existence of the investment dispute. Again, that is a jurisdictional fact. So unquestionably, in order for the tribunal to identify that there is indeed a consent to arbitrate, it has to decide fact-intensive matters. And there may be, within the consent to arbitrate, or within a scope of application of the treaty provision, a statement that the treaty or the consent to arbitrate does not apply to disputes prior to the entry into force of the treaty. Again, that's another jurisdictional matter that the tribunal is going to have to decide upon in order to assess whether or not there is a consent to arbitrate. Now that sort of exclusion of prior disputes, or an exclusion so far as concerns investments made before a certain date, that can be contained in a consent to arbitrate. Very equally, it can be contained in a scope of application provision that identifies what the treaty itself applies to. So it may say the treaty does not apply to investments made before 1950. That, regardless of whether it's within the consent of arbitration or not, is a jurisdictional matter which the tribunal will have to decide on as a matter of fact in order to determine whether there is consent to arbitrate. Now 11.1.1 contains very similar sorts of facts or jurisdictional matters that go to jurisdiction. So when it says this chapter applies to measures adopted or maintained by a party, it's saying this chapter in its entirety, I'm not sure the court understands those words differently to me, this chapter applies only to certain measures as defined that must be adopted or maintained by a party. Again, as defined, because you can see the definition in Article 11.1.3. So all 11.1.1 is doing is identifying further or or as a precursor, I shouldn't say further, they establish up front certain jurisdictional criteria, facts, that need to be established for the application of the chapter. So, investor of the party, other party, again, that may be a very fact-heavy issue, but you have to decide that in order to say whether you have jurisdiction. Same with covered investment. Same also with the question of whether there is a measure adopted or maintained by a party. So it is very common indeed for ubiquitous international arbitral tribunals to have to identify as a matter of fact whether certain jurisdictional criteria are met. And the point I'm making here is that there is nothing untoward about those sorts of jurisdictional criteria being contained up front in a provision like Article 11.1.1 and not just in the consent to arbitrate in 11.16. Now, against that backdrop, I would like to take you to some of the cases that show how tribunals have consistently approached 11.011 NAFTA, which is the materially identical provision in the NAFTA, in precisely that way. And I do that to show you the clarity of the existing cases on this point.
When you say the existing cases, what is that if you say you're establishing by them that tribunals have adopted this approach? What is the approach we should take to the decisions of various tribunals?
Absolutely. What weight should you accord to those? Then there are two answers to that. We say, and there's no dispute about this, they are persuasive or not. You may take the view that the court, that the wording is not persuasive, and ultimately you've seen that the judge was not ultimately persuaded by the NAFTA awards, although he did recognise the potential for being persuaded. You can see that paragraph 63 of the judgment at 694.
Presumably, if they set out or follow the approach that you have adopted,
yes, my lord,
then does it help us to see that they've done that when you could tell us there are X number of awards that have followed that approach? And how does it help us to see that tribunals have accepted this in their own words? I'm just wondering what we're going to get from this.
Well,
presumably they will articulate the approach that you've set out to us now in the course of quite an extensive period.
They will, my lord, that's absolutely.
If there was any arguments in there that were particularly persuasive, you would no doubt have or will deploy them. So what does actually looking at them help? Why does it help us to look at them? You could say to them there are 693 tribunals who followed this approach. I'm just trying to understand what we're looking at them for.
Well, I'm just trying to. I would be taking you to them, say, just as one example, just so that you can see the way that they reason and whether that's persuasive or not. so that you can see who is deciding these issues. The judge there you see referring to highly distinguished tribunals, so it's a factor to be borne in mind who is actually making these decisions. But we also say that when you're looking at them in the context of the circumstances of conclusion of the treaty, several of these awards, which were very well known, were in existence prior to the treaty being signed in 2007, and several more prior to the treaty coming into force in 2012. So they come in, we say, in two different ways, both as a form of persuasion and as a form of Article 32 supplementary means.
The judge draws a distinction between awards which were in the public domain before the treaty was signed. He says only one for sure, possibly a second, and awards which come later. Is that a valid distinction?
Well, it's certainly valid to be looking at, when the treaty came into force, we'd say there's actually a significant delay between the treaty being signed and it coming into force. And the treaty was actually also amended at a certain juncture in 2018. So we say the 2007 date of signature is not the only cut-off point that the judge should be looking at. We also say that one of the factors for you, separately to the diplomatic note, but under Article 32, is to be looking at subsequent practice. And the subsequent practice here, as to the meaning of Article 1101(1) of the NAFTA, but also to a limited extent the meaning of 11.1.1 of the Chorus FTA, is also a factor that falls within Article 32 of the Vienna Convention as supplementary means.
Mr. Wordsworth, just to note, it's 12:15 now. We expect you to finish today. To some extent, how you use the time is up to you, but we don't want to be told at the end of today there are 17 other things you should be looking at before you decide the case. It's a case about oral argument, and we have 2 days allotted, which is quite generous. It might be that you have sufficiently referred to the other cases on which you want to rely in your skeleton argument, but seems to me, speaking for myself, one could spend hours going through other quite complex awards, and then was it on identically worded provision? The judge in the present case wasn't considering 11.1 in isolation or 11.16 in isolation, and as you say, other awards can't be binding, they can only be persuasive. How persuasive they are depends on a number of factors. How identical or nearly identical is the wording, and so forth.
My Lord, I absolutely have your point on timing, and I also pick up on a certain lack of enthusiasm in terms of going to these cases, but it is at least important to be looking at them in the light of the consistency and the persuasiveness, and also the fact that it enables me to deal with some of the points that the judge made on the cases at paragraph 63. So, for example, he says there does not appear to have been any argument before those tribunals that Article 1101 did not condition the state's consent to arbitrate. That in fact is not correct, because one can see in the Methanex case there precisely was an issue joined between the parties as to whether Article 1101 had the effect that we contend for. Perhaps at least I could give you those references.
No, please don't do that.
No, okay.
Case about oral
absolutely.
argument.
Yes.
You might like to start with your best case, whatever it is, and we'll take it on from there.
Thank you very much for the indication. In that case, can I take you to the Methanex Authority at tab 5212. And can I ask you to turn to page 247. This is a decision in the form of a partial award. The tribunal was chaired by V.V. Vida, QC, certainly a highly distinguished international jurist, and you can see from 247 that the tribunal is considering both challenges on jurisdiction and admissibility. So it is keenly aware of a distinction which really the judge was drawing between challenges which truly go to jurisdiction and those which merely go to a question of admissibility. And you can see that again at 248. Challenge 1 is Article 1116, Challenge 3 is Article 11011 NAFTA, and then at 86, first as a general principle explained in Chapter 1 below, we cannot address, and this is looking at Challenge 1, we cannot address it as a challenge based on admissibility. Second, as a jurisdictional challenge, it fails on the wording of Article 1116.1 because it is an indisputable fact that Methanex has made a claim that Methanex has incurred loss and damage. So the challenge 1, by reference to 1116, by reference to there not being a breach with being the proximate cause of the alleged loss, the tribunal says, no, that goes to admissibility. We simply cannot decide that. Then if I can ask you to turn to 258 and paragraph 106, the tribunal's power to rule on the USA's challenges necessarily derives from Chapter 11 NAFTA. In this respect, the scheme of Chapter 11 may be described as follows. Article 11011, this is the gateway leading to the dispute resolution provisions of Chapter 11. Hence, the powers of the tribunal can only come into legal existence if the requirements of Article 11011 are met. Then, following on at 108, you can see the tribunal on page 260. You can see the tribunal distinguishing in the fourth line there between the USA's challenges to jurisdiction, which primarily concerned Articles 11011, and other provisions of Section B of Chapter 11, Articles 11, 16, 17 and 21, while the USA's challenge to admissibility concerned substantive provisions under Section A. And then it explains how the challenges to admissibility work, and then explains that it is not able to decide those. Then there is a debate which starts on 261 as to how to approach jurisdictional facts for the purposes of this preliminary phase of the proceedings. See, at 112, it was common ground between the disputing parties that for the purposes of the jurisdictional phase, Methanex was not obliged to prove its allegations of fact, and that it was sufficient that Methanex should credibly allege the factual elements of its claim. But when it came to its final award in 2005, the tribunal had reserved a potential for there being jurisdiction under 1101, and the tribunal decided that issue as a matter of fact. So it considered that it was a factual matter going to the very existence of the scope of the consent to arbitrate in order to for this to be, that had to be decided. Then if I can ask you to turn to 270. Uh, 127, the scope and coverage of Chapter 11 NAFTA is limited expressly by Article 1101(1) NAFTA. It provides that Chapter 11 applies to measures adopted or maintained by a party relating to A, investors of another party, or B, investments of investors of another party in the territory of a party. So you can see it's materially identical wording. And then at 281, after a detailed consideration of what the relating to requirement within 11011 requires, they conclude at para 147, we decide that the phrase relating to in Article 11011 signifies something more than the mere effect of a measure on an investor or an investment, and that it requires a legally significant connection between them, as the USA contends. Pursuant to the rules of interpretation contained in Article 31(1) of the Vienna Convention, we base that decision upon the ordinary meaning of this phrase within its particular context and in the light of the particular object and purpose in NAFTA's Chapter 11. As indicated above, it's not necessary for us to address other submissions advanced by the USA in support of its arbitration. So the tribunal then applies that test to the case before it, and you can see that at 291, para 169, as regards the USA's jurisdictional challenge under Article 11011 NAFTA, the tribunal decides that certain allegations advanced in Methanex's amended statement of claim relating to the intent behind the US measures can potentially meet the requirements of that provision. At this stage of the proceedings, however, it is impossible for the tribunal to make a definitive ruling on jurisdiction without a fresh pleading and accompanying evidential materials from Methanex, and accordingly that ruling will be postponed by the tribunal until one or more further awards. So it is expressly treating this, we say persuasively, as a matter going to jurisdiction and as a matter that it cannot decide finally until it has heard the facts. So, as to the position that the parties were taking, and you recall I just showed you paragraph 63(1), where the judge says there didn't appear to have been any argument on the jurisdictional status or not of Article 1101. If I could take you to tab 31, and sufficient to take you to 3735. You see the US position there.
So can I just check? Which bundle are we in?
Bundle
Bundle
3.
2.
No, sorry, I think you should be in Authorities Bundle 1, tab 31.
Tab 31 in mine is the start of bundle 2.
So,
Well, my bundle 1 goes up to tab 30, and my bundle 2 starts at tab 35.
right.
But I can make do with what's on screen if you don't have it. Perhaps you could find the rest.
Okay, I do apologise. But if I can ask you just to read 113, so you see the position being taken by the USA.
Sorry, is this the final award?
No, sorry, I'm just taking you to the parties' pleadings.
Oh, the pleadings.
Because the judge was making the point that these weren't disputed matters at all. I'm just showing you that in Methanex there was a dispute as to this.
Well, the award you've just shown us says that there was no dispute about measures. There was a dispute about relating to.
My lord,
the
yes.
tribunal decided they couldn't. They could only decide that when they'd heard all the facts. Is that what it comes to?
That is precisely what it comes to.
Why does the pleading of the or position statement of the USA
Because
help
you
us
can
beyond
see.
that?
Because I'm simply addressing paragraph 63(1) of the judgment. So the court there is saying there doesn't appear to have been any argument before those tribunals that Article 1101 did not condition the state's consent to arbitrate. And I'm just showing you the USA position at paragraph 113 at 3735. And then the corresponding Methanex position, which you can see at tab 32, and I apologise again for any issues here, at page 3755, where you can see right up front, Methanex is taking the position that in the third sentence, the objections collectively suffer several overarching flaws. They do not address jurisdiction at all. You can see that point is then furthered in the next paragraph. If I could just ask you to read down to the middle of the page.
How do we have pleadings of parties from an trial arbitration?
It's very common, my lord, because of the requirements of transparency in investor treatment cases.
So these are published?
Needs to be published, yes. And then page 3800. They're making the point that NAFTA Article 11.101 does not address the jurisdiction of this tribunal. They say that's without merit. And you can see at bottom 3804, they flesh out that argument to a degree. So this was a matter as to which issue was taken between the parties. And it's, then if I can just take you to the second Methanex award where they decide on the jurisdictional issue, and that is at tab 7 of the authorities bundle. Ask you to turn to uh, 594. So, paragraphs 1 and 2 there, if I could ask you to read those. And then 601. Paragraph 18, I could ask you to look at that. You see the tribunal is applying the balance of probabilities test to Article 11.011. And then the approach of the tribunal at 604. Its summary and conclusions. Given the tribunal's decision so far in this award as regards the jurisdictional issues under Article 11.01 and issues under Articles so on, it is unnecessary for the tribunal to decide other issues relating to the merits. So it doesn't even, I mean, it then goes on to decide them for completeness, but it is pinning its decision on the jurisdictional issue under Article 11.01. You can see that again at paragraph 5 at 605. And then you can see that in the order at paragraph 611. So, in taking you to Methanex, there are several points that I'm trying to bring out. First of all, this is a case that the US itself has placed considerable weight on, and it establishes, so far as concerns the US, a consistent line of the position that it takes with respect to 11.01 going to jurisdiction, and it is also consistent with a long line of cases showing that 11.01 does indeed go to the existence of the consent to arbitrate. I'm also taking it to you so that you can see that while at paragraph 57, the judge who was looking at the Methanex award says, I accept that this highly respected tribunal adopted an interpretation of NAFTA which analysed the requirements of 11011, the equivalent of Article 11.11 as conditions of the state's consent to arbitrate. Important feature, partial award was delivered at a stage when the tribunal was unable to determine any issues of disputed fact. Yes, correct. But when it came to the final determination of jurisdiction, the tribunal considered that there were facts that had to be decided on the balance of probabilities in order to decide that it lacked jurisdiction. So we say, so in fact, that point there, that's not correct, and that's where he gets to the conclusion there at 57.4. It will be immediately apparent that this involves a concept of jurisdiction which is meaningfully different from that contained in section 30, where jurisdictional facts as well as jurisdictional legal arguments must be definitively determined. Well, no, there isn't that distinction, because Methanex decided that its jurisdiction under 1101 turned on the existence of jurisdictional facts which had to be decided. Finally, and having finally decided those facts, it considered it no longer needed to go to the merits at all in its final award. So the judge's observation there on Methanex, we say, is incorrect. He was aware...
How does this work? This tribunal finds at the partial award stage it hasn't got enough facts to say whether the measures related to investor. After hearing all the facts, it says, I hope this isn't an inaccurate summary, no intent to harm the investor, therefore not related to, therefore no jurisdiction.
Look, so the way it works is at the partial award phase, it says, assuming all the facts in your favour, claimant, which I can do at this stage, even if assuming all those facts, there is no jurisdiction with respect to all your claim as it stands. However, you have flagged up an amendment to your claim which is based on the fact that this particular Californian legislation was individually targeted at you, the claimant. Okay, we see that theoretically, if that's right, then that would meet the relating to standard. So we will hear that matter separately, but we will decide that. We can't assume your facts in your favour on that, because if we assume the facts in your favour, well, the relating to test is satisfied. Article 11.01.1 is satisfied. So they have a trial, full trial with witnesses, and that is one of the issues that they decide at that second trial, partial, and at the final award.
Right. Why does that help you?
Because the judge is saying here that the approach of the tribunal in the Methanex case is to not decide by reference to jurisdictional facts. And I'm making the point that for a matter to go to jurisdiction, you've got to decide as a matter of fact, is there an investment or not? Is there an investor or not? It's obviously a mixed question of fact and law. The judge here is saying, well, hang on a sec, in Methanex, in the partial award, they didn't follow that approach. And hence, this isn't the Section 30 jurisdictional type issue, like the existence of an investment. I'm saying, no, that is not wrong, because there's nothing wrong with the tribunal's approach in the partial award to assume everything in Methanex's favour and say there is no jurisdiction. But with the one issue as to where the facts mattered, as to the existence of jurisdiction, those facts had to be decided, just as a matter of fact, you would have to decide on the existence of an investor, of an investment, or any other jurisdictional criteria that fit within the question of whether there is consent to arbitrate.
As far as Methanex is concerned, simply on the question of its persuasive force, for what I can see, despite it being an august body of arbitrators comprising the tribunal, it's a decision based upon what one could see at best quite limited argument, and certainly nothing like the sort of argument that's been deployed by us. I find it hard to see how that tribunal was in anything like as good a position to determine that point as we are today, with the benefit of your extensive arguments and those of the other side. So I'm not sure how persuasively it can take the matter very much further forward.
Well, my lord, I do think the sort of distinguished tribunal point is one that has to be borne firmly in mind. That's true, for example, when you get to the next examples in the judgment at 59 and the 60. So 59, again, a highly distinguished public international lawyer presiding, Professor Vaughan Lowe, and saying in very clear terms the role of Article 1101 in determining the scope of the jurisdiction of tribunals established to hear Chapter 11 claims is clear from the title of the article and so on. Just because there hasn't been such detailed argument as there was in front of Mr Justice Foxton doesn't mean these highly distinguished arbitrators have been wrong.
Well, the judge records at 63.1 there doesn't appear to have been any argument. I know you've shown us some argument, Methanex.
Yes.
But not very much.
Not very much, my lord. I'm not going to, obviously, but...
No. And
but it was a contested issue.
You have to bear in mind that at that stage, it doesn't matter a great deal for the arbitral body whether they look at it in terms of jurisdiction or admissibility, does it?
My lord, with respect, it matters a very great deal, because so far as concerns the Methanex tribunal, as I showed you, it was acutely conscious of the issues of what went to jurisdiction or admissibility, and considered it had no power to decide matters that went to admissibility, because those weren't contained within the trial rules. In addition...
But it doesn't matter to the party, though, does it? It just doesn't matter to them how they lose.
Yes, it does. It matters a very great deal, my lord. Because if you are a state, you're in the invidious position, in its essence, of always being the respondent in investment treaty cases. So if you lose on a jurisdictional, on a matter as to the existence of the consent to arbitrate, then it matters a very great deal that actually does or does not go to jurisdiction, because then you have an opportunity to challenge at the courts of the seat. Otherwise...
No, I can see that. I'm thinking about the investor. It's the investor's arguments that it seemed to me might have been put rather more forcibly.
My Lord, I'm not in a position to say. I can just simply say that the judge's observation that it really doesn't matter in general terms, either to the tribunals or to the parties. Tribunals, it matters a very great deal indeed, because they know that they are subject to challenge at the seat.
But they're subject to challenge however they categorise it, aren't they?
Of course,
as we have here.
Of course, that's correct, my Lord. But they will be giving thought to that issue. That's the point I'm trying to make. They're not just these highly distinguished public international lawyers. They are not looking at this issue without reference to the practical ramifications.
Now, is there any argument other than that which you've shown us in Methonex?
No, I don't believe there is.
So these points were just not argued in this tribunal?
Well, what would the points have been? I mean, they would be by reference to 1116, but the key point that the judge placed so much weight on, which was the existence of consent to arbitrate with respect to investment agreements and investment authorizations, that was the key point for the judge. And that's not in NAFTA. And he was saying, well, I understand the approach under NAFTA, but that doesn't apply so far as concerns porous FTA. And the point that I'm trying to make by reference to Methonex is not just a point by reference to the persuasiveness of the reasoning. We say it is persuasive, just as we say these other tribunals are, but also that it feeds into the consistent practice of the USA and all the other NAFTA parties who say that Article 11011 does go to jurisdiction. It does precondition the parties' consent to arbitrate. So you have an agreed position of all three NAFTA states. They've all said this at different junctures, that 11011 does go to the existence of the consent to arbitration. You will have seen the US position in the diplomatic note. You may recall there's a very long footnote of the cases where it has said again and again that 11011 goes to the consent to arbitrate. But we can also see that so far as concerns the other NAFTA states, if I can just find the references to give you. Just excuse me one moment. I don't want to delay. I'll come back to those after the short adjournment to make that point good. But it's the consistent position of all three states with respect to the NAFTA, and what we say is materially identical wording so far as concerns 11011.
Now, if you're done with Methonex, the judge goes on at paragraphs 59 to 62 to other awards from which he quotes, which tend to favour your argument. We'll take it that he's accurately quoted from each of the awards. Is there any of them where you feel we need to know more about the case than is set out at paragraphs 59 to 62. If not, then you can move next to other material or what the judge says at paragraph 63, which is obviously important.
My Lord, just on paragraph 60, where you see the reference to the Canadian Cattlemen for Fair Trade case.
Yes.
Absolutely, of course, it's correct, the description there of Article 1101 as a key article in terms of the entire chapter's coverage and scope, quoting Methanex. But the judge says those are jurisdictional requirements which might well have been derived from Articles 1116 and 1117. Just to make the point that that is not how the tribunal approached this, because this was the very unusual issue of Canadian investors having an investment in Canada, which they said had been adversely affected by a US measure. And so the question was whether there had to be an investment in the territory of the other party. And the tribunal placed very heavy weight on 1101 because that does concern, under two of the limbs, express territorial requirements. It only then looked at 1116 and 1117, where it was not so able to find any express territorial requirements, but it looked at them really by way of simply confirmation of the correct position by 1101. And if you read the reasoning there, I think it's doubtful to say which might well have been derived directly from Articles 1116 and 1117. I think the tribunal placed very considerable weight on the express territorial requirements in 1101. That's the only point I would make there.
Well, as the judge says it, 63(2, requirements about the nationality of the investor and the location of making of an investment. He describes as intuitively jurisdictional.
Well, that point that it's intuitively jurisdictional is one that sort of ties back to his approach to say, well, I consider that there are certain core jurisdictional issues, like whether there's an investment or not, whether there is an investor or not. And he is reading that territorial requirement, i.e. an investment in the territory of the other party, regarding that as part of a core jurisdictional issue. The question is whether you can get to that by reference to the wording of NAFTA. And NAFTA, unlike the current treaty, the definition of investor of a party is simply an investor of a party who makes an investment, not an investor of a party who makes an investment in the territory of the other party. So it is a sort of a much more serious issue under the NAFTA as compared to the Chorus FTA, where you can get to a
Excuse me.
a sort of a territorial restriction by reference to applying the definitions so far as concerns Article 1116. My Lord, I see we're approaching the short adjournment. I've just been asked to ask your permission. Can the parties work with the clerk over lunch to sort out the authorities bundle.
Oh, yes. Certainly.
So, I can go to 1 o'clock, my lord, or if you'd like to sort of pause here, I'll move on to my...
You'll know better than I whether you have 2 or 3 minutes to go to the end of a paragraph, so to speak. If you're about to move on to a new part of the argument, you can stop now.
I will stop now.
Right. We'll return at 5 to 2. I'll ask my clerk to come along and do what